Hi, my name is Jackie Stevens, and I typed the first Stevens Squibs back in 2004. I'm most proud of Eddie for taking this from a homegrown, self-typed, photocopied and mailed out to a select list of attorneys that we thought could use it, to a project that benefits the most vulnerable in our community. Along the way, he and R.T. White were the highest grossing CLE for the Family Law Section CLE Committee. Now, instead of raising money for lobbyists, the money from these subscriptions is donated directly to the Center for Child Counseling. The Center for Child Counseling helps the most vulnerable in our community in Palm Beach County, and the money that is raised by these subscriptions goes directly to them with no fees taken out. Eddie has never benefited financially from this project. Eddie's speakers have never benefited financially from this project. The volunteers that help him have never benefited financially from this project. This labor of love, every dime goes directly to the Center for Child Counseling for their projects that help the most vulnerable among us. The cool thing is, we're gonna let you see what Stevens Squibs has to offer by giving the first hour and a half free. I've seen Eddie work on these squibs for over 20 years, and to say it's a labor of love is not an understatement. He uses this as an educational moment, one of these people who finds that he learns better when he writes things down. He knows this case law, and he's willing to pass on what he has to offer, what this season's episodes have to offer you by giving this first hour and a half free. So please take a look, and knowing that your subscription will benefit the Center for Child Counseling, please consider subscribing this year. Thank you, and take good care.
Hi, I'm Eddie Stevens, and welcome to Stevens Squibs Monthly Family Law CLE. This is the 13th episode and the beginning of Season 2. We have done this as a learning process for ourselves, but over 20 years it's kind of developed into a tool where we can educate others and raise money for really good causes. For 10 years, we did this as an annual CLE for the Family Law Section. By directing the revenues to a charity, we think we're doing a really good thing. So to introduce you to this season, we are giving the first hour and a half away for free. If you like what you see, subscribe. You're going to get 15 hours of board certified marital and family CLE for $300. You can't beat that deal anywhere. On the 15th of every month, a new episode drops and you can watch it at your convenience. We hope after you watch episode 13, you'll subscribe to the rest of the season. Ritualistic behaviors I find very grounding, like coming out here with my family and communing with nature every week. I found writing case law summaries to be very similar. Not only have they kept me informed and knowledgeable, but it's kind of grown organically into something I never expected, and now has turned into a really neat way to raise money for worthy causes. While this episode we're going to talk about 50 cases, normally we have other elements to the show. For example, board cert tip of the month. We interview living legends in family law, and we love to have attorneys involved in appeals come and explain really what happened behind the scenes. I need to thank Renee Lehman, the CEO of the Center for Child Counseling, Dominica Nolan, who is my tech and registration guru, and of course Karen Stevens and Gina Sapucki, all who put incredible efforts into this project. I challenge you, make our monthly CLE one of your monthly habits. You will not be disappointed.
Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stephens.
Good afternoon and welcome to season 2 of Stephen's Squibs monthly family law case law CLE. I am honored to have with me my two co-hosts, of course, Karen Stephens and Gina Sapucki. How are you guys doing today?
We're back.
Can you believe we got picked up for season 2?
I know it was a little sketchy there, but we pushed through. The networks still like us, so it's good.
Well, we made a whole lot of money last year for the Center for Child Counseling, and we're going to try to not only repeat that, but kick some butt and raise a whole lot of money
and step it up this year. Yes.
If we get 1,000 subscribers, we can raise $300,000 for charity. We're not quite at 1,000 subscribers. We're closer to 100. So spread the word with your friends.
We're just about 800 short or 900 short. So
just shy, no big deal.
Well, making $500,000 the second year would be kind of incredible. So let's shoot. That's our goal. And since we have limited ways of advertising this, we would ask that if you like this, share this with your friends and tell them to sign up, because we got a year of CLE and it's going to be awesome. So today's episode, we don't have any guest speakers because we took last month off, and we have 50 cases that have come out in 2 months. So between myself, Gina, and Karen, we're going to hit every single case. To get us started, Karen, let's talk about alimony.
Alimony. And it is not ironic that we have 50 cases this month, because our illustrious Eddie Stephens, this is his last CLE episode before he turns 50. So we could not have planned on any better. So,
and I'd like to thank Alfredo the Spark for that lovely introduction, just because it's fun to be roasted on your 50th birthday.
Absolutely. And if you haven't seen the full Alfredo, we're totally pitching that you need to Google him. He's amazing.
Very funny.
And who would think this is 50? Come on. I mean, really.
So if you want to send Eddie an email and wish him a happy birthday, I'm sure he'd love to hear it. And if we get 1,000 subscribers, we could maybe make this 50-year-old do something crazy. So
I would rather have the 1,000 subscribers than emails, but that's just me. Back to alimony.
Back to alimony. Yes, let's get the attention off of the 50-year-old. So anyway, the first alimony case this month is Taylor versus Davis, which is a first DCA case out of Duval County up there in the Panhandle. And this was a very short marriage, 3 years. And shorter than most people's college careers. And unfortunately, before these folks married for 3 short, wonderful, loving years, they cohabitated for 24. I know we've all had those consults where the folks come in and say, yeah, but we were together 18 and we were together 10. Cool. So these folks were married 3 years and 24 years of cohabitation, no cohabitation agreement, no prenuptial agreement, the normal, we just lived together. And the Duval County Circuit Judge decided that he was going to essentially give credit for all those wonderful years of cohabitation with or without a cohab agreement. And he ordered that Miss Davis receive $3,000 a month in permanent alimony due to her very short 3-year marriage. And there was a whole discussion about the fact that this judge wrote in his final judgment that given the unique circumstances of the parties and all of this nonsense, not really super unique. We've seen the cohabitation happen before, but Florida doesn't recognize palimony. We can't give credit for the years that we derived as a living together cohabitating couple unless there's a contract about it. And to make a long story short, just going through the statutory factors in the judgment like this judge didn't somehow rise it to the level of the unique circumstances that required Mrs. Davis to enjoy permanent alimony. So this was reversed and remanded back for the judge to do some proper calculations, because there just wasn't those exceptional circumstances that we all need.
Yeah, I love the one line that the first says, that there are no legal rights or duties flowing from cohabitation. So I think that could be used in many instances. And
Yes.
I thought it was a very learned comment from coming out of the first.
And I think Gina's going to take number 2.
Yes, now we're on Gardy v. Gardy. It's a fourth DCA case, and this was the husband appealed a final judgment of dissolution of marriage, claiming that the trial court erred in them awarding only $3,000 a month of durational alimony for 3 years instead of having the court award him permanent alimony. And he made a few claims in his appeal, mostly saying that the trial court did not calculate his true need and the wife's true ability to pay. Again, they awarded durational instead of permanent alimony, and a couple other things which I will not go into. During the trial, what had happened is the parties acknowledged that this former husband was currently on a SSI disability and that he was disabled due to work, but he was testifying that he could perform some work and that he may be able to become employed later on. There was a lot of testimony about that. There was testimony about how the former wife had a surplus income of over $5,000 and the former husband's financial affidavit showed a deficit of over $5,000. So there was a lot of testimony going into that about how the trial court started chipping away essentially at his deficit for failing to account for friends and family, giving him continuing gifts every month. He was putting expenses for household that he wasn't paying. And prior to this trial, there was a temporary relief order where the wife had to pay him temporary alimony and continue on his health insurance, especially due to his disability. There was also testimony at the final hearing about how much was he or was not disabled. That was the main question. And the husband really was sort of self-reporting his own issues, which led the trial court to make this presumption that because he wasn't consistent in his testimony and he kept saying he was attempting to work, he couldn't know if he could work. This made the trial court skeptical as to, are you permanently disabled or not? The court found that they made equal contributions to the marriage. This was on the low end of what we call a moderate term marriage, since it's 8 years, and a moderate term is between that 7 to 17 year time frame. So the appellate court reviewed this. As you know, alimony is awarded for abuse of discretion. And what had happened here is the appellate court said there was no error. It was a 15-page final judgment. They made all the required statutory findings in accordance with Florida law. And one of the main portions was his own testimony about whether he was intending to work or not didn't help with permanent alimony. And the trial court also made mention that he was awarded all the proceeds of the house, which helps with a lump sum payment. And that takes us to the last case of alimony for this episode.
Case number 3, Smith v. Smith. This is really an appellate case in addition to alimony. No transcript, but the appeal was successful because the amount of need on the face of the judgment included expenses from an adult child, and they saw that in the record on a financial affidavit. So one of the rare circumstances where someone got by appealing an alimony award without ordering the transcript, but you can see why. That is the Smith case, and that takes us back to appeals. Gina?
Thanks, Eddie. The first case of appeals is the O'Day v. O'Day case. This is dealing with a non-final order that the wife appealed during the pendency of a divorce. Essentially what had happened here is the husband domesticated a judgment outside of he went and got a final judgment of divorce in another country, domesticated it here to Florida. Wife filed a petition, and in the interim, she filed a 57-105 motion for sanctions. And when his domestication was dismissed, they weren't going to hear her 57105 motion at this time because the divorce was still pending. So when the wife appealed this non-final order, the appellate court said that a 57105 is not appropriate yet because it's not final. The purpose of a 57105 is it's essentially punitive in nature. So that is basically saying you made a baseless claim, and because the petition was still pending, the court could not look to that, as opposed to a temporary a motion for fees under statute 6116, which is making someone having this similar ability to obtain a hearing as opposed to sanctioning someone. That takes us to the next case of appeals.
Google Me versus Google Me, I think. Sorry.
That was a good try. I like it.
A plus for effort.
Google Me. Not bad for a 49, almost 50. Never mind. This was looks like a malpractice case because the person who appealed an order denying a motion to vacate instead of the underlying order. The appellate court had a problem with that, said if you don't appeal the right order, we don't have jurisdiction to hear your appeal. So hopefully the attorney for the moving party there has their insurance policy paid up. Attorney, that takes us to the Schmidt case. Karen?
Yes, the next case under appeals is Schmidt. This is a 4th district case out of Palm Beach down here. One of our guest hosts, RT White, who often graces us through these Squibs CLEs, was the appellant attorney in this case. We love RT. And what this was is there was an order finding entitlement to attorney's fees, but not amount. And as we all know, should know, practice tip to remember, a order that finds entitlement but not amount is non-final, non-appealable. So this case wasn't ripe for the district court yet, and it was just dismissed.
I think in the year and 1 month we've been doing this, that pattern of cases has presented itself the most. So I think the appellate court's trying to tell us something.
I would agree.
Case number 7, Smith v. Williams and Bailey. That's dealt with a issue that the father could not successfully appeal an order denying a motion for contempt without demonstrating an error on the transcript. Again, we have fees that are determined but entitlement but not amount, and we have no transcript cases dominating what's coming out of these appellate courts. On to something more fun, attorney's fees.
Staying with the same theme, but also attorney's fees and appeals. This is the Smith versus Fenton Smith. So we have I think 3 or 4 Smith cases this month. So you know what they say about the Smith name. Very common. So here we go. Here's Smith case number 3 so far. This is a 5th district court case out of Lake County up there in the middle of the state. And this involved attorney's fees being awarded to one of the parties. However, in the final judgment, there was no consideration for the financial positions of the parties post-judgment. And that is something that the court needs to take into consideration and not just blindly award attorney's fees, because what happened in this case is that the parties were left in pretty substantially equal positions after the final judgment was entered, and none of that was considered, and the fees were just awarded. So this was reversed and remanded and told the trial court to recalculate the fee award, if any, based upon the final positions of the parties after the judgment. So that is the 3rd Smith case of the month.
Well, the good thing about the Smith is it's hard to misspell it, maybe like Stevens.
Right. No other way to spell it, just the one way.
Well, there's one way to spell Stevens properly at least.
Sure. Right. Exactly.
That debate will go down in the annals of great debates.
We won't even try spelling my last name. It's fine.
I will bow to the elder on this one, so it's all good.
Oh,
you're welcome.
That's unfair.
But at least most people say it right, unlike poor Miss Sapucky over there.
Sapucky, what other way to say it?
Oh God.
Sapucky.
I will be here for 5 minutes if I go through all the ways I've heard. which that takes us to enforcement. I'll be doing the 2 enforcement cases for this episode. The first one, number 9, is Moore v. Moore. This was out of the fifth district. It was a post-judgment dissolution of marriage case where former wife filed a motion for contempt and enforcement of an MSA for monies that the former husband was supposed to pay her in accordance with that settlement agreement. The former husband appealed this ruling, saying that the court failed to credit him $11,000 in payments that he had already reimbursed the former wife for. At the time of the hearing, the former wife conceded that he did reimburse her this $11,000 credit, and therefore the appellate court affirmed in part and reversed by saying, trial court, you have to go back and give him this $11,000 credit. That takes us to number 10, Finch v. Cribbs. This was out of the first district. This case is post-judgment. The former wife filed a motion for contempt for the former husband, failing to pay permanent alimony and a personal loan. The court had held him in contempt, and they also sanctioned him because throughout this case, the former wife had a lot of issues getting discovery from him, and he appealed, saying that, saying the court erred and saying he had the ability to purge this payment and a bunch of other things. What I really like about this case is just a quick little procedural history is they had a final judgment in 2014. Former wife then filed her first motion for contempt 2 years after, trying to hold him in contempt because he didn't pay any alimony or any money towards his personal loan. Right before that hearing, they entered into an agreement to resolve the whole contempt. The former husband conceded, said, I will pay you a lump sum payment of arrearages owed. We'll do another monthly payment of what I have remaining. In addition, we're going to keep what we're paying, and in addition to what he was still supposed to pay. Well, the former husband didn't do that either. So former wife had to again file another motion for contempt. And when she did it this time, she sought financial discovery. It took well over a year. The former husband mostly didn't turn over discovery. There were sanctions throughout with the court. At the final hearing, this forced the wife to hire a financial expert to testify as to the former husband's income. He was self-represented. So the trial court essentially found that he was in contempt, he didn't pay, he had a lot of arrearages, and they also sanctioned him for the wife having to go through all this discovery. So the former husband naturally appealed, and in order with a motion for contempt, you have to, when you do a purge amount, you have to make sure that it's on the contemnor's present ability to pay. So here, when they ordered a substantial purge amount, they had to go on the facts that this former husband had the actual ability to pay. However, because he didn't do discovery in his testimony, he was not credible, is what the court found. Here, when you have a party who is self-represented and they own their own business, and essentially they are voluntarily not providing you discovery, the trial court isn't only limited to what that party has available at that time. They can also look to other assets that this person may have who is self-employed. So this expert testified that he was taking a whole bunch of business money, moving it into his personal account, and he could not testify or account for anything about that. So the appellate court said, trial court, you're correct. Based on his testimony and all the evidence we found of him moving business money and the fact that he has a bunch of business assets available, they were correct in saying you have to pay this purge amount. And I believe that takes us to equitable distribution.
Yep, equitable distribution. We have three cases in this month's CLE, and the first one is Tanner versus Tanner, first district case out of Nassau County. And if it sounds familiar to you, what I'm about to talk about, you are not crazy. We did discuss the Tanner case. Me specifically talked to you about it back in April. There was a new superseding opinion, which is the one that is before you right now, that replaced the opinion that came out in April. And the Tanner case, there was a motion for rehearing and reclarification, or I'm sorry, and clarification, which is what rendered this current opinion that superseded the last one from back in April. There were 5 issues raised on appeal, a multitude of things about verbatim adoptions of proposed final judgments, whether trial to court abused discretion in awarding alimony to the wife, discretion was abused, and whether the wife was given beneficiary status of the husband's life insurance policy. But the most exciting part of it, which is the same thing we talked about in April, was the fact that the court distributed the future parking passes and season tickets to the Georgia football college football games, and the trial court distributed those in part to the former wife as a function of the final judgment. And of course, the first district said that because the future football tickets and future parking passes to those UGA games were not assets that were acquired during the marriage because they hadn't been awarded yet or given to the parties yet, it was an error to include them in the equitable distribution scheme that the court did put in place. So it is college football season, so it is very timely that the Tanner case was now superseded again with this new opinion, and you still can't give out future football tickets and future parking passes, even if those are super valuable and very important to us college football fans. I understand Mrs. Tanner's position. So
Karen, I wonder if the first DC up in Tallahassee, if those were Seminole tickets, if they would have reached a different result.
I would have to believe, despite the fact that I'm in orange today, do not let that mislead you that I am very much garnet and gold bleeder. But I think I probably would have fought like Mrs. Tanner for those football tickets.
So the next one, I want to say omelet, but I think it's ume.
Ouimet.
I stand corrected. Ouimet, of course.
There you go. Try that.
Ouimet. I don't know. It's the citation's there. In this case, the court distributed a retirement to both parties, but the only evidence was the financial affidavits, which had that little mark that said non-marital. And there was no evidence, it wasn't addressed, nothing contradictory to that. So when there's no evidence presented to the contrary, that little check mark on the financial affidavit will do the trick. And in this case, it did. So actually the trial court was affirmed for declaring it non-marital based on the check mark. The next one is the Sanders, and we're at number 13 in the materials, 13 of 50, Sanders v. Peterson Sanders. The trial court didn't address 5 credit cards on the husband's financial affidavit, and therefore there was no evidence presented. Those seem to be errors that the appellate courts are willing to correct. Now we are moving into injunction world, and on the flip side of 50, this will be the last injunction cases we talk about, for me at least. Bill v. Wilson was a stalking injunction and really dealt with severe emotional distress. You had 2 people in kind of an online relationship, didn't really know each other, broke up, and once the breakup happened, one of the parties started doing things like reporting the other person to work, sending out messages to friends, but nothing really crazy. It may have caused some distress and embarrassment, but in the context of a petition for stalking, the question is whether the communication rises to substantial emotional distress. And that distress should be narrowly construed to be, a reasonable person standard, not a subjective standard. Wilson, the petitioner, testified that the respondent would argue, threaten self-harm, but admitted they were never violent, never threatened violence. And whatever was sent to the petitioner's employment, the petitioner said, well, they had no repercussions. Under those circumstances, you don't reach the level of severe emotional distress required for a stalking injunction. Gina, I think you got the next one.
Yes, the one, it's actually number 15, Cyrus v. Cyrus from the First District. This is the case where there was a petition for injunction filed. When the temporary order was granted, this appellant was, of course, required to surrender his firearms, and thereafter there was a final hearing, and a permanent injunction was entered on this appellant. About a year later, he filed to move to dismiss his injunction, claiming multiple reasons, just one that the appellee at the time had moved and she's over 2,500 miles away from him, and X, Y, and Z. When they had the hearing, the trial court denied his motion to dissolve the injunction. So the appellant here appealed to the trial court. And a great practice tip is the main issue here is the appellate court couldn't give a ruling on whether the trial court made a clear abuse of discretion to deny his motion, because he forgot to give a transcript of the hearing to the appellate court. So without a transcript, the court cannot determine whether this court committed clear error, and that burden is always on the appellant who's filing the appeal to provide to the appellate court. So unfortunately, this case was affirmed, and that takes us to our next case.
So our case number 14 is Bradley v. Slyman. It's the first injunction case, and it dealt with a party seeking to dissolve a injunction for protection. And basically his excuses were, it's been a year and a half and I haven't bothered the petitioner. I've moved on with my life. The appellate court found that these bare-bone allegations were legally insufficient to dissolve the injunction and reversed the trial court. And the appellate court noted, more importantly, we conclude that the evidence presented at this hearing was woefully insufficient to support the granting of the respondent's motion. The petitioner did not stipulate to the facts set forth in the unverified motion to dissolve injunction or made during opposing counsel's closing argument. In the absence of a stipulation, unsworn representations by counsel do not have any evidentiary weight whatsoever. So if you're going to dissolve an injunction, there's got to be a reason, and there has to be a reason, and there has to be a change in circumstances that no longer require the underlying injunction. Going back to Bilby v. Wilson real quick, it was public school media posts that are damaging to someone's reputation. They just don't form the basis of an injunction. 17, Whitfield v. Meeks. This was a overcrowded DV docket. The judge complained that I have 5 cases to decide in this hour. The respondent said, well, I have a bunch of witnesses. And the judge said, well, we'll see if you really need to hear those witnesses at the end. The witnesses were going to deal with veracity, testing the evidence, and the judge basically denied the respondent the right to call any witnesses. And at the end noted, I find that one of these parties are lying through their teeth, and there is a basis for an injunction, and I believe there was violence. And they did that without giving the respondent the opportunity to present evidence to contradict that. And therefore, due process was violated, and the Whitfield Meeks injunction was reversed.
That's like a huge oops.
What happens, courts have control over most hearings, and like temporary relief hearings, they can cut you right off and they're not going to get in trouble. But there are so many DV opinions out there that say if you don't give that respondent the opportunity, the true opportunity to put on a case, and I know some of these, most courts jam pack 8 to 12 injunctions in a hearing. And if they have a real contested injunction, they're going to have to set that one aside and deal with it and give it a full evidentiary hearing, otherwise easily reversed.
We see a lot of those ones too, where folks are bringing up new allegations that aren't in the petitions all the time at these hearings, or filing supplements to it that aren't served on the respondents and things like that. So there's a whole litany of those kinds of cases too that get reversed.
Yeah, technically, you're not supposed to bring up anything that's not in the filed and served injunction, so they have notice. And some of the districts are a little wishy-washy on that, but we're pretty strong in the fourth.
So sticking on injunctions, we're going to go to number 18 in your materials. Sorry, it's been a long day. Caddy versus Robinson, and this is a 4th District case from Broward County. And there was a domestic violence injunction entered between these parties in favor of Ms. Robinson back in 2016. And for some particular reason, back 4 years later in 2020, that domestic violence injunction gets vacated because the respondent surfaces now and says that he did not have proper notice of the 2016 hearing, now in 2020. So I guess in quarantine, he realized there was a domestic violence injunction against him and he should probably participate. So the 2016 order is vacated. Now it's 2020. The court resets the 2016 injunction for a hearing now in 2020. And at that time, the court enters a DV injunction again, and this time gives the petitioner 100% time sharing with the party's kids, sole decision-making authority, and all of that. However, the problem is between 16 and 20, when this original injunction was entered, the parties went through family court and entered into a marital settlement agreement and resolved all the issues about their children. And the 4th District said that if there's an underlying family case, or if there's a pending family case, these provisions that are in the family law forms for domestic violence and things like that, where you can check off, time sharing and all of that, it should not be the primary vehicle for determining custody of children and time sharing and decision making if there's a contemporaneous or a counterpart of a family court case going on, and that the family court issue should have been dealt with in family court and not through the domestic violence procedures and machinations and all of that. So I know that a lot of us over the years, you've seen cases where, wives and husbands file domestic violence injunctions with or without merit, sometimes in the middle of a divorce case, in an attempt to sort of trump and get ahead on exclusive use of house or child related issues. So this case makes it very clear in the 4th that if there's a contemporaneous or a counterpart family case, that the child related issues specifically needed to be dealt with in there. So it was reversed on the issues of the child custody determination made by domestic violence court and the parental responsibility determination. And the court had an interesting quote that the better practice in such a case would be for the trial court to just enter that temporary order in domestic violence and then direct the parties back to family court to figure out the rest of it. So that is the Caddy and Robinson case. I think Eddie's up next.
Tana, this is a interesting injunction case that dealt with the breakup of a relationship where one of the parties was a doctor. And then the other party found some what they thought was disturbing criminal behavior of the other party. And the opinion doesn't really tell you what it is, but it seems salacious. There seems to be allegations that one of the parties was having sex at the hospital with other people during COVID-19. And basically the petitioner thought that this was a significant health risk that needed to be reported, not just to the authorities, but to the employer, to friends, to other people. And the court entered an order of injunction and enjoined the respondent from communicating with the petitioner's employer at all. So it got reversed in part, affirmed in part. The issues where the petitioner was complaining to the police or to the hospital, the court deemed that even though it may not be the primary reason, there's a credible purpose there. So we're not going to base an injunction on that. But they did find that all the other correspondence to the neighbors, to friends, that constituted um, enough sufficient basis for a stalking injunction. The court did reverse the portion that prevented the respondent from communicating with the petitioner's employer, because we all have a constitutional right of first free speech under the First Amendment, and that action constitutes a prior restraint. So that provision in the injunction was stricken. Lots of injunction cases these past 2 months. The next one is number 20, Peck v. Rosado, and that dealt with neighbors. And they came in on a motion to violate, and the court actually modified the injunction, so that was reversed because no notice. And there was also an issue that the injunction really had insufficient directives of how this person could live next door to the petitioner and yet stay 500 feet away. So for that reason, the entire contempt order was thrown out as well.
That takes us to number 21, the Marquez v. Rivera case. This was from the 4th DCA, and this was a consolidated appeal, 2 appeals that were both non-final orders brought up to the appellate court. Both were ex parte temporary injunctions. One was against domestic violence, and the other one was for stalking. Neither have had a final hearing at this time. These temporary injunctions were entered originally in January 2020, and as of December of 2020, so almost a whole year, these 2 ex parte temporary injunctions still have not been to final hearing, and they have been continued already multiple times. So what had happened here is the appellant finally appealed this last continuance, arguing that there has not been a showing of good cause to warrant this. Neither party filed any motion stating any reason for good cause, and especially in temporary injunctions under the statute, when you cannot show good cause to continue the hearing, the court has to hear it. So here, this case was reversed and remanded back down. That takes us to the next injunction case.
Yes, the next injunction case is number 22 in your materials, which is the Freeman versus Rogers case, 2nd District, Polk County. This involved a stalking injunction that got entered against Ms. Freeman. These were 2 females. It was entered against Ms. Freeman, and she filed a motion for rehearing, which was timely to this stalking injunction, and said that she had difficulty appearing at the hearing. And the trial court just blanketly denied her motion for rehearing, despite it being timely and despite it actually alleging some valid concerns and circumstances. And she did not get to appear at this hearing despite her best efforts. It was all during COVID and virtual courtroom things. And she said she called in and tried to appear and getting kicked off by the court process or whatever the situation was. So the 2nd District reversed and remanded this for the lower court to either conduct a hearing on Miss Freeman's rehearing motion, or just in the alternative to actually reset the stalking injunction hearing and conduct it with both of the parties present this time. So that is the Freeman case.
So that brings us to our next case, which is Waite v. Chapman, which is another injunction case. And the respondent appealed it, and it went up to the 2nd DCA. And during the appeal, the injunction expired. And therefore, the appellate court issued a motion to show cause why we shouldn't dismiss the appeal for mootness, and requested a response from the appellant petitioner or appellant respondent to have an appeal go forward. Some mootness exceptions, there's 3 of them. 1, it has to be a question of great public importance. 2, when issues are likely to recur. and 3, where collateral legal consequences affecting the rights of a party flow from the issues of a case. And I think there's a whole lot of case law out there that say a DV injunction certainly affects other rights that flow from that case. So it seemed like the appellate court was begging this appellant just to give a good reason. Unfortunately for the appellant, she just re-argued her original petition and did not address the court's request to show why it's not moot. Even though I think we can all agree, we understand that exception number 3 would probably do the trick. So out came an opinion and on mootness, if you ever need it, case number 23 in the materials. Case number 24, another injunction case where we are dealing with firearms and stalking. Apparently, giving up firearms is not something that happens in stalking injunctions, and specifically 7840485 sub 5 teaches us the things that we can do. There is a catch-all phrase in the statute that allows a court such other relief the court deems proper, but removing someone's right to bear arms in a stalking injunction is not included. So the trial court was reversed by the second DCA in that case as well. 25, halfway there, our last injunction case of the day, again, deals with social media. Sending a social media friend request or non-threatening contact made through a third party, not sufficient to establish severe distress required to establish a stalking injunction. Now, modifications.
Modification lands. I have the first modification case number 26, the Patel case. This is a first district Walton County case. These folks were divorced in 2016. There's a final judgment, and under the terms of that final judgment, the former wife had the majority time sharing with the party's children. So 3 years later, after the final judgment, the former husband comes around and files a motion for contempt and or enforcement and a motion to appoint a parenting coordinator, and alleges in the contempt and or enforcement motion that we're talking about that because of his schedule as an ER doctor, it is impossible for him to comply with the time sharing schedule that was ordered back in 2016. And note, he filed a motion for contempt and enforcement alleging those circumstances. So this goes to hearing. Also, he asked to have a parenting coordinator appointed and some other things in his motion. And the court actually set a hearing and modified his time sharing under the motion for contempt and enforcement. And the former wife appealed this case and took it up to the first district. And the first district said, well, the order on the contempt and enforcement motion didn't anywhere in there say that there was a substantial unanticipated material change that had occurred, nor were those allegations made in the motion, nor did those allegations or those words even appear on the record, transcript of the proceedings whatsoever. And because of that, the court doesn't have the authority to modify a time sharing schedule under a motion for contempt and enforcement, and the proper vehicle should have been a supplemental petition if dad's circumstances had actually changed. So this was reversed and remanded, and without these findings of the substantial material unanticipated change and without the proper vehicle brought before the court was without jurisdiction to change anything. That is the Patel case.
Number 27, we have a supportive relationship case, the Klakow matter. Klakow, blah, blah. The court found a supportive relationship, but did not offset alimony by the amounts being used to support the paramour. I love using that word, or the boyfriend. Boyfriend had expenses, former wife was paying for them. Alimony should not go to pay those expenses and should be set off dollar for dollar. Court also erred not dealing with the reduction of the husband's income. He had a pretty significant reduction that was not addressed. Both items got returned back to the trial court. Number 28, Idelson v. Carmer, a second DCA case. The parties had a provision in their marital their parenting plan, that they would modify it based on one small instance. The court ended up using that provision to modify other parts of the parenting plan without a substantial change of circumstances. So the second sent that back and said, well, the one modification that the parties agreed to that didn't need a substantial change of circumstances, no problem with that. But if you want to change other stuff that was outside of what the parties contracted for, you're going to need to find a substantial change of circumstances. And in this case, those did not exist. So it was reversed in part, affirmed in part. Number 29, I feel like we've gone to the dogs because we're fighting over dogs. And, you know, I love dogs more than anybody, but they're just chattel. They're just personal property. If you ever have a dog dispute in mediation and you offer to cut the dog in half and give one party half the dog and the other party the other half, that's usually going to resolve the issue for you, because the one who says give him the dog should probably keep the dog.
Pretty
In this
sure
case-
that's an old tale, isn't it? Like a fable, Solomon, something like that, Eddie.
It's from the Bible. It's biblical.
Okay, just checking. So you don't claim any rights to that theory, but all
But-
right.
But that's where our whole law is you know, based from. And then, you know, we have
Sure.
English, France, if you're whatever. It's always good to cite references. So going back to the
I mean,
Springer
you could,
case.
I was going to suggest you do it with kids too, but hey,
So-
you know, I'm
Well, if you watch Schitt's Creek, kids are not an asset; they are dependent.
right, exactly.
The kids.
That's why I have a dog.
If you haven't watched Schitt's Creek, I apologize, and it's spelled a little different.
Spoiler
So-
alert.
Going back to the Springer case, well, that was season 1. It's not a spoiler.
First episode.
Springer v. Springer. The dog. So one party gets awarded a dog, the other party says, don't do that. And the judge agreed with them. And instead of awarding the party the dog, they awarded the fair market value of the dog. And we're talking about a used dog, so that probably wasn't very much. That was reversed because property distribution is not modifiable. So the court could not distribute the dog to one party and then modify the decision to distribute an amount of money that would, I don't know. I don't even know how they determine the fair market value of a dog, but you can't do it. That's what Springer teaches us on to parenting.
Okay, parenting. I was just thinking of maybe becoming like a dog appraiser, something like that.
I mean,
I mean,
don't they have functional obsolescence pretty quickly? I mean,
like a car, when you drive it off the lot, it's already depreciated, right?
I mean, what kind of dog are we talking? It doesn't even
I mean-
say. Are we talking one of these fancy ones that you have to pay a lot of money for? Or I don't know.
The rescue mutt, who knows?
I
Anyway,
I feel more sorry for the dog than the two parties. That's for sure.
so let's talk about human kids. All right, parenting. We've got the Lewis case, which is number 30 in your materials. And this is a final judgment was entered. Final judgment of divorce says that the former wife gets ultimate decision-making authority, quote, on all major decisions involving the children. And major decisions are defined as including but not limited to decisions regarding education, healthcare, and other responsibilities unique to this family. And if you're sitting there saying, gee, I've written that before, yeah, we probably all have. However, this final judgment that the court wrote had that same kind of language. And the 4th district said that that is not good enough. So when you're awarding someone ultimate decision-making authority over major decisions, you must delineate the very specific aspects of the child's welfare that that parent is being designated or delegated the authority to make the ultimate decisions on. So saying the major decisions are included but not limited to language is not good enough. And the 4th district cites to statute 6113 2C 2A, 6113 2C 2A. And that is the part of the statute that says that ultimate decision-making authority must delineate the quote specific aspects of the child's welfare. So that is the Lewis case. So make sure if you're sending in proposed final judgments that you don't just put that illustrious language that we all love to write, which is just all, including but not limited to, which is not enough.
And I think Lewis and some other cases that have come out lately really say that you just can't give one parent unbridled parental. You do have to break it up. And usually we break it up. If we try to get everything, it's educational, medical, extracurriculars, because that covers a lot of it. But there are many unique circumstances. Our next parenting case 31, it was an opinion that had already come out, the Pacini Waxer case. We had spoken about it before. One of the parties submitted a rehearing, and the 5th DCA gave kind of a smarty pant response and said, except for this factual error that we made in footnote number Z, affirmed. So I thought that was just kind of the 5th being a little spunky.
All right, we're on to number 32, which is Barack v. Barack. And interestingly enough, Mrs. Barack's first name was Michelle. So if you're following along in the history of our country. So anyway, very interesting. Nonetheless, this is a 4th district case. This is out of Broward County again. There was a final judgment entered in 2019 that gave these parties 50-50 time sharing with their children. And former wife comes around in 2020 and files a motion to temporarily suspend and or modify the time sharing against the father of these children. There is a litany and a wildfire of multiple post-judgment motions that followed after mom's initial motion to suspend time sharing. Guardian ad litem is involved, there's therapists involved. They can only imagine the number of docket entries that were involved. And the court actually conducted a pretty lengthy trial on this issue. And the court ultimately entered a big, massive omnibus order that covered all of the pending motions that were out there. It temporarily suspended dad's decision-making authority. It transferred custody of one of the kids fully to the mom and left the other one at 50-50. It delegated. The problem with it really was that it delegated the resumption of dad's time sharing and decision making to other people to decide. And we all know we can't do that, but the court was really trying here to figure out what to do with these multiple docket entry type families. And the final order that the court wrote said that once the reunification therapy, individual therapy, and any residential program that mom identifies and completes, and the individual therapist selected by mom makes the recommendation to this court, then we can reconsider time sharing. So that is improper. Dad did also argue in his appeal that there were no concrete steps listed out for him to regain the custody with his children. And the court did note that the Supreme Court resolved that conflict under the CN-IGC case that we discussed earlier this year, and that you don't need concrete steps anymore. So they determined that that argument was moot. However, the problem with this case was the delegation of authority, that you can't give someone else control to make those decisions, even in the most difficult and acrimonious of crazy of cases that the Barack case must have been. So that is our last parenting case this month.
Thank you, Karen. And that takes us to, wait, we still have a few more parenting.
It's still me, sorry. No, we moved on to procedure. So whoops, I couldn't mute myself fast enough, but I'm back. So number 33 is the Gray versus Gray case. This is our first procedure case this month. And then I'm taking a break and muting myself for a few minutes. But so this is a 5th District Orange County case. There was an order that partially granted the petitioner's second motion for rehearing. There was a very, 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 very brief MSA that was actually proffered onto the record because these parties were set for trial and they had been fighting and litigating their dissolution of marriage for 8 years, by the way, 8 years. And then it resulted in a 3-page MSA, which probably had some issues in it. But nonetheless, the parties were arguing post-dissolution about some of the language in their super lengthy 3-page MSA, and were arguing that things were ambiguous. There were IRA and 401k transfers that were supposed to occur, and one party was saying, well, it doesn't say when, the other one was saying, yes, it does. But to make a very incredibly long story short, and an 8-year divorce shorter than it probably should have been, the court, on the motion for rehearing and clarification, rewrote some of the parts of the party's settlement agreement. And for a 5th district went through a very detailed analysis in that you can clarify a judgment to make it clearer and more precise. But when you change stuff that alters the status quo or the obligations of the parties, that goes way beyond a clarification and becomes a modification, which is what the court here did, and it was improper. So the district court also said that they found nothing unclear and ambiguous about the parties' very short agreement, despite them arguing that the provisions were ambiguous, the same ones that they recited on the record. But this case was reversed and remanded basically because the court rewrote provisions of the MSA that shouldn't have occurred on a clarification motion. So that is the Gray case.
Speaking of a court exceeding their authority, case number 34, Perez v. Maldonado, out of the 3rd, it was noticed for a non-evidentiary hearing and outcomes and order dealing with visitation that was not stipulated. So again, you got to stick to what's noticed. The court can't go beyond that relief unless for some reason it is tried by consent, which is one of our favorite jujitsu moves in court. More on that later. Case 35, Gina?
That is the Schultz v. Schultz case out of the 3rd district. This is a post-judgment dissolution case. The parties entered into an MSA where the former husband was required to make certain payments to the former wife until it was paid off, with contingencies that upon death, remarriage, or cohabitation with another person, those payments would cease. Come to find out, the former husband stopped making his support payments, so former wife filed a motion for contempt and enforcement on the former husband. When she filed that motion for contempt, she also filed a general discovery request seeking financial documentation from the former husband. What he did thereafter is he responded by saying, because you are cohabitating with somebody else, and that's part of what's in our MSA, that implies that I no longer have to pay you alimony and it's now terminated. He also filed a general objection to her discovery request asking for his financials. Then thereafter, the former wife filed a second motion for contempt, which asked the former husband to produce all surveillance and all investigative matters that were related to these claims that the former husband was making, saying that she's cohabitating with another person and therefore it triggered the MSA. The trial court overruled the former husband's objections on these discoveries. So former husband filed this writ of certiorari, which is what the appellate court is overlooking at as to whether the trial court made these proper objections as to discovery. And what the appellate court has said is that although the husband may make a decent argument about how his financials may not be relevant if he stipulated saying, I have the ability to pay, there's 2 issues with that. One, the former husband could not pinpoint to any place on the record for the appellate court to say that he in fact did stipulate that I have the ability to pay this amount if the court determines that this clause was not triggered. And then the second portion is the appellate court stated that the trial court was correct in requiring the former husband to produce all this surveillance documentation that he planned to use at this hearing. The former wife is certainly entitled to these documents that he intends to present at trial. So therefore, this petition was denied. That takes us to case number 36.
And we're going to breeze through a couple of these procedural cases because they teach us something, but the facts aren't, that interesting. The first 36 cases, Saad v. Sheikh. The trial court denied an evidentiary hearing on a properly pled motion to reform a contract due to mutual mistake. If you have, a sufficient pleading that requests appropriate relief, the court really should allow an evidentiary hearing on it. 37, Conklin v. Perez. The entire thing was affirmed except to fix one scrivener's error where it said respondent instead of petitioner. So that was imagine getting that as your opinion. 38, AV v. TLL. This dealt with witnesses testifying by telephone, and in our new Zoom world, it's gotten even more interesting because in this case, to testify by phone, you have to have good cause. In Zoom, you don't. So these, our Zoom world and our courtroom world seems to have this little hiccup where you have a lot more freedom to bring in witnesses on a Zoom hearing from all around the world, that if you were in court, you need good cause. The problem was compounded because it was a telephone appearance and there was no one there to properly swear in the witness. You need to have a notary on the witness's side to identify and swear them in if you're going to do a phone appearance. I would like to see this rule addressed, especially in light of Zoom. I guess Zoom you can identify with a driver's license, but I can never read the driver's license when it's thrown up on that little window. So I would suggest that area of law needs a little work. 39, in Ray amendments of the Florida Family Rules of Procedure 12510. If you didn't know, summary judgment has changed, and this is the Supreme Court opinion that changes the rules of procedure regarding that. So too much to talk about in this issue. We can spend a whole seminar on that, but be sure you're aware of it. Number 40, Marino v. Powell, dealt with a writ of prohibition, and the appellate court really went crazy on the attorney for taking things out of context and not presenting things maybe as they actually were. Even more helpful in this case, there's a warning that if you take a case, you better be, and it's set for trial, don't expect a continuance. You have to be prepared to try that case. So, whether or not this deals with disqualifying a judge, it's got some great language whenever someone's trying to get a continuance just because they were just hired. So be mindful of that. The Lycabak case, I don't know if I got that right, out of the 5th, interesting technical case. During a dissolution, motion for contempt filed, mom sought rehearing. Before she sought a rehearing, she filed a motion. After she filed the rehearing, she filed an appeal. After the appeal was filed, an opinion came out on the rehearing. So the court lost its jurisdiction right there when the notice of appeal was filed, and it was not reserved, and the order that the trial court issued turned out to be a total nullity. All right, 42, DeGamo v. Mascarello out of the 3rd DCA, deals with amending your pleadings. And we all know, liberal justice liberally construes and allows the pleading, except in certain circumstances. Here, it was the Friday before the trial, and it changed request where before the wife wasn't seeking alimony to she was seeking alimony. So under these circumstances, the court was affirmed for properly denying the wife's motion to amend. 43, Bender v. Hornback out of the 2nd DCA. That dealt with basically an emergency motion to domesticate, but there were a couple issues. There was no emergency alleged in the motion. So you can't grant an emergency motion unless you find that there's an emergency. Also, there was issues with complying with the domestication statute 61528 sub 2 sub B. So that order was reversed. Case number 44. It's an amendments to the Supreme Court approved forms, and it deals with changing some of our injunction pleadings to conform with the 2020 new legislative changes, including the dog rule.
That takes us to case number 45, the Orozco v. Rodriguez Amadio case. Hope I didn't butcher that too much. This is an initial dissolution of marriage action filed in 2017, where the husband, a couple years later, with the action was still going on, he filed an emergency motion to suspend the wife's time sharing with their child. What had happened here is the trial court had a hearing on that within 12 days, and they did grant his request and gave temporary sole time sharing and parental responsibility to the husband of this minor child. So the wife appeals. This is a non-final order because the initial action has not been finalized yet, stating that on the same day that the husband filed his emergency motion to suspend time sharing, her counsel filed a motion for a leave to withdraw, and she consented to that. But husband's attorney, there was a conference and this emergency hearing was held 12 days later. His allegations in the emergency motion were basically that the wife was interfering with this husband's reunification, and the wife was coaching this child into making accusations about this husband. So at the hearing, the wife was pro se because when the judge granted her motion to withdraw, they said she had 30 days to get a new attorney. Wife showed up to this hearing. The husband, it was his motion, so he went first. There was extensive testimony by the court-appointed psychologist, by the guardian ad litem. And what had happened here is midway through, the wife was not given an opportunity to present her case and cross-examine all of these husband's witnesses. There's also made a point that she was not even able to call her own witnesses who were sitting outside the courtroom waiting to be heard. And midway through this trial, the judge sort of interrupted and he immediately issued a ruling. So what the appellate court had said here is this did violate the wife's due process rights to affording her a full and meaningful opportunity to present her case. And the appellate court also made mention that this is not the same as if a parent went and filed an emergency temporary order on the grounds of physical harm, or if a child's about to be removed from the state, where that gives a little leeway to due process rights. But here, because the husband only made the allegations of wife interfering with this reunification, that doesn't justify her being able to have a full opportunity to present this. So this was reversed and remanded back for a new hearing.
Right. Number 46 is the Logriera case out of the 3rd District, Miami-Dade County. Interesting read. It's a 4 or 5 page opinion. We're still under procedure, but this was a post-judgment issue, and there were many motions filed post-judgment and petitions pending on both sides. So much so that the trial court conducted a 9-day post-judgment bench trial. So probably one of the lengthier ones I've ever read about as a post-judgment process, but nonetheless, 9 days occurred. So clearly this court had invested some great judicial labor and time into crafting together orders and opinions and making rulings. The court modified the parenting plan of the party, sent these folks to the Family Bridges program, which is a parental alienation specialty program where they take everybody away and put them somewhere and try to work through these parental alienation issues. So clearly there was some significant acrimony and controversy and arguments going on with these folks. But what actually happened is that the parties sent in proposed orders, but after that, the former husband sent in a supplemental order and correspondence to the court, which was not solicited or requested by the court, and said in his letter that basically a decision had to be made on this other extraneous issue so that the Family Bridges program could get signed up and running for these parties and this family. And this unsolicited order that the former husband sent in was signed by the court before the former wife could respond. And clearly it was an order that had nothing to do with the lengthy 9-day trial that had occurred and was supplementary to that. And the supplemental order that was signed gave the former husband much more power and discretion than what was ruled upon by the court after their lengthy 9-day trial. So this was problematic. Former wife didn't get a chance to be heard or respond on it. And there was some due process issues among other craziness that went on. And the court, the district court, third district, recognized that clearly the underlying trial court had expended much effort and judicial labor on it, and they were probably really trying to help, but that signing the supplemental order that they didn't ask for was improper. So that is the Logriera case. And now we're on to the last few here, 47.
47, Lopez v. Frometa. And this is an interesting case where a motion was filed and the court set it for hearing 3 hours after the motion was filed. That was reversed just for a violation of the other party's due process. In a similar issue, well, not similar, but procedural, Sanders v. Peterson Sanders, the appellant complained that he was limited to 3 hours in his trial presentation. However, during the trial, the husband never objected to the time limitation, and apparently the record reflected he was not prevented from presenting any evidence whatsoever. So the trial court here in Palm Beach County was affirmed on that one.
So we're going to hop over to support. We have the last two cases here, number 49. This is the Cooper case, 5th District, St. Johns County case. Probably the simplest, quickest opinion that I'm going to go over this month, which was the court recalculated child support, but miscalculated the number of overnights. So court used 72. There were actually 78. It was very clear in the judgment how many overnights dad had. So that was reversed, and the court was told to use the right number, run child support again. And so that leaves us with number 50, last case, going to the soon to be 50-year-old.
Light some candles, let's start a fire. And it's kind of anticlimactic. The Haddad case, the trial court forgot to attach child support worksheets to its judgment, and it was reversed and remanded. So we know how child support was calculated. And that takes us through 50 cases for 3 months. I'd like to thank my co-host, of course, Karen Stevens and Gina Sapucki, for doing all their hard work, keeping up. We took a month off. Next month, we'll have some more guests again, but we wanted to make sure we hit all the cases for you. And I want to thank Alfredo Rivera, also known as the Spark. He's the comedian who did the Frontier Airlines roast for me at the beginning of the program. And
That was pretty good there.
Yeah.
There you go. Clearly he's watched it a few times.
And we have done a couple other things. We did a great DEI seminar for the family law section. We thought that was very needed. We have some articles coming out of me being choked out. Be sure to take a look at that. You'll see a series of pictures where I turn purple. And
you need you need a footnote on that one, Eddie. We're talking about jujitsu. Yes.
Just to clarify, jujitsu.
Yeah.
So if you take a look at the next commentator, you'll see me unconscious if you're interested in that kind of material. Thank you all for joining us on our first episode of season 2. How exciting.
Yay!
And we can't wait to put on a year's worth of awesome CLE for the low price of $300 for the entire year. So if you thought this was informative, interesting, or at least for funny looking, again, please share this with your friends so words gets out, and 100% of the money raised goes right to the Center for Child Counseling to help the most neediest children in Palm Beach County, the most vulnerable. and we're very proud to be doing this for such a good purpose. So until next month, we'll see you on October 15th on the flip side of 50.
Bye, everybody.
Thank you for joining us for this month's edition of Stephen Squibb's Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.
Every dime of this project goes directly to the Center for Child Counseling, to their projects that every dime it won't leave me alone now. Every dime of this stop. As soon as it must
I'm going to tag this to the end.
Funny.